On the road between Orlando and Gainesville, Florida, a small city in Florida's horse country, Ocala, Florida, is the home of a distribution center for the online pet supply retailer Chewy. And at Chewy's Ocala, Florida warehouse, a forklift operator was crushed and killed in what is known as an underride accident, an accident where a forklift operator might back into a structure at a portion of the forklift that's unguarded and thereby striking the operator himself or herself. And that's what happened at Chewy's warehouse in Ocala. Chewy's defense to the citation that OSHA issued was that it had fully complied with OSHA's powered industrial trucks standard, Section 178, and therefore could not be held liable under a general duty clause alleged violation. An administrative law judge reviewed the citation and disagreed with Chewy, and that went up to the review commission, and the review commission agreed with both OSHA and the administrative law judge. Chewy brought this matter before the U.S. Court of Appeals for the 11th Circuit, and the 11th Circuit reversed, stating that the hazard of an underride striking a operator was addressed by the powered industrial truck standard, and therefore OSHA should not be bringing this under the general duty clause, and that Chewy could not be held liable under the general duty clause. We're going to cover that standard, the decision in Chewy, and what this means for the employer community as we move forward in this episode for June 14, 2023 of the OSHA 3030. Well, hello, everyone. I'm Manesh Rath. I'm an attorney at the law firm Keller and Heckman here in Washington, D.C., and I practice in the field of occupational safety and health law. I've been doing this for almost 30 years, and I've been putting this material on as a podcast for the OSHA 3030 for almost a full 10 years now. I'm grateful that on this episode, as with many of the episodes in the past few years, I'm accompanied by my good friend and my colleague, Taylor Johnson. Taylor, welcome to the OSHA 3030.
Manesh, thanks for having me, as always.
Well, we've got a great topic, as always. This is a question of the scope and applicability of the general duty clause, particularly when an employer feels like there's a specific standard that covers the matter being cited. So what are we going to talk about today?
Yeah. So first, we're going to start with just a basic primer in what the general duty clause is. And then we're going to discuss an earlier case, a 1987 DC Circuit case, U.S. Department of Labor versus General Dynamics. We'll then go into the 11th Circuit Chewy case, Chewy versus the Department of Labor. We'll review the ALJ's decision and the 11th Circuit's decision in that case. And then, as we always do, we'll wrap up with what employers should do, some practical takeaway items for folks to bring back to their workplace.
Right. This is a pre-recorded episode, so we will not have a off-the-record section specifically for our live audience. And we apologize for that. We really love the off-the-record section. We get some great questions from members of the OSHA 3030 community. So keep those questions coming. Send the emails in. We'll hope to do another off-the-record session, hopefully next time. But let's get into the Chewy case, starting with a discussion of the general duty clause. So the general duty clause, it comes from the Act itself, the Occupational Safety and Health Act, the Occupational Safety and Health Act of 1970. And that is the statute that enables, first of all, the agency itself, and it empowers the agency to promulgate standards. OSHA has promulgated many standards under that act. But there's also another clause in the act that says that there is a general duty for employers to provide a workplace that's healthful and safe for workers. And this idea is the foundation for citations alleging a violation of this clause. So it's a higher standard for the agency to have to establish a violation of the general duty clause than to establish a violation under a specific standard. The thinking going that the process of promulgating a standard is the opportunity for OSHA to establish a lot of the elements of a violation, including the idea that there is a hazard and that it's recognized by industry, and this economic and technical feasibility question. They should all be addressed in rulemaking for a specific standard. But the general duty clause, if OSHA is not citing under a specific standard, but citing under the general duty clause, it now, in the context of a specific citation, has to establish those elements. So now, citing under the general duty clause instead of a specific standard, OSHA has to meet 4 prima facie elements in order to prove that the general duty clause was violated.
That's right, Manesh. And the first is that workers were exposed to the hazard. This is actually the one carryover from the 4 general elements that OSHA needs to prove on a regular citation. Yeah, need to prove exposure.
Always employee exposure is elemental in every citation. And the second, that the hazard that they're alleging is a generally recognized hazard.
Third, that the alleged hazard was likely to cause or did cause death or serious physical harm.
Right. And finally, that if OSHA is alleging a violation of the general duty clause, it has to establish that there is a feasible means of abatement. So these are the 4 elements that OSHA has to establish anytime it provides a allegation of a violation of the general duty clause. But let's talk about a case that was decided, I think, in 1986.
87.
87. Thank you. Good job, Taylor. And that's the U.S. Department of Labor versus General Dynamics.
Right. So what happened in this case is that there were multiple reports, incidents of employees who were reporting ill, certain physical symptoms due to alleged Freon exposure. The Freon was actually used in the plant at the time to clean up oil spills. And so OSHA came out, did an investigation, and they issued General Dynamics a general duty clause citation.
It's an interesting case because there is a Freon standard, and they chose to issue a general duty clause citation violation.
Right, exactly. They essentially chose to do this because what was happening at the time was that the workers were inside of a confined space. This is actually pre-confined space standard.
Yeah, it was a tank, right?
Right, exactly. The hull of an M1 Abrams tank, I believe. And so what was happening is, I think OSHA's argument was that sort of the general levels set for Freon exposure did not cover this particular sort of concentrated air situation that the workers were exposed to.
Right. They were pouring Freon into the engine block, the engine
Exactly.
cavity, as well as into the turrets. Is that right?
Yep.
Okay. So that for the purpose of removing oil.
Yes.
So that they believed was not contemplated within the scope of the Freon standard, and so they believed that the general duty clause was all they had left. The court felt.
Yeah, the court agreed with OSHA. They said that in this case, the compliance with the air contaminant standard was not enough to get General Dynamics out of a general duty clause violation. And then in general, that compliance with OSHA standards, does not per se discharge your statutory obligation to provide employees with safeguards against recognized hazards.
Right. It's hard to say I agree or disagree. I think that the relevant space that they may or may not have exceeded the permissible exposure limits to should have been the confined space into which the Freon was being released. And in that context, they may have violated the specific standard, resulting in OSHA not having to use the general duty clause.
Certainly.
So I'm not sure that that's a persuasive case, but when you talk about the release of a hazardous chemical that is potentially fatal in its exposure, it's understandable that the court would maybe come to the conclusion it did just to get to the result it wanted to. Okay, so we wanted to talk about that case as background because it really sets down a position that some in the OSHA community have relied on, that the specific standard may not be the beginning and end of the story, and that it's possible for OSHA to exceed the boundaries of a specific standard and use the general duty clause to issue a citation. But let's talk about the Chewy case that we're here for today.
Yeah. So Chewy operates a warehouse in Ocala, Florida. And then what happened here is that a forklift operator was crushed and killed in an underride accident. So a forklift underride accident, it occurs when the forklift operator travels with the forks trailing, backs up into a storage rack so far that the forklift passes beneath the horizontal crossbar, sort of enters the driver's area, and then can crush, the operator inside the compartment. So that's what an underride is.
And when that happened at the Chewy, Ocala, Florida site, the compliance officer conducted an investigation and cited Chewy, and they cited them under the general duty clause. Remember, the fourth target that OSHA has to meet under the general duty clause is that there's a feasible means of abatement. And Chewy, of course, contested the citation, as we've already said, but the one of the things that became an issue of contention between the two was this idea that there's a feasible means of abatement. The compliance officer said, well, you could have put a lower shelving down than the lowest shelf. The lowest shelf was so high that it created a possible struck by or underride hazard. And the alternative would be to have put on an add-on guard on the forklift itself. Either way, something would have struck first rather than the operator being struck. Either the lower shelf would have hit a portion of the forklift, or the bumper would have hit the shelving. So that was the final element, which is the feasible means of abatement question.
Right. Yeah, and specifically on that point, just to give a little more background, so there were 2 prior incidents with forklifts at this facility in 2018, and the safety manager for Chewy at the time did actually recommend that specific measure of abatement, Manesh, that we should just lower the height of the shelving itself to prevent this from happening. Management decided to not pursue that option, but the fact that was out there, I think definitely cut against Chewy in this case.
Right. Chewy argued that whether or not they had to or could have implemented these simple fixes to the shelving or to the powered industrial trucks, they didn't have to face this analysis in court because they did comply with the powered industrial truck standard. And it's a compelling argument, but the administrative law judge disagreed with Chewy and sided with the secretary.
Right. And the secretary's main argument really is that the specific hazard here, so the hazard of an underride, is not squarely addressed in the powered industrial truck standard. And so that's sort of the reason why they go to general duty clause here. That's what they really need to prove in order for their argument to win the day, is that you may have, and you do have, training aspects of the powered industrial truck standard and sort of safe operation guidelines that Chewy hangs its hat on. But the secretary says that that's not enough. They're allowed to go outside the bounds of the powered industrial truck standard here and go to general duty because that specific underride hazard is not squarely addressed.
Right. Taylor, let me say that a different way. The secretary argued that when you look at the powered industrial truck standard, it doesn't specifically address underride hazards.
Right.
And so we should be entitled, OSHA said, to use the general duty clause.
Right.
Chewy's argument was, well, if you look at the powered industrial truck standard, it actually does address underwriting hazards in the form of its training requirement. It requires that employers conduct training to teach workers how to use powered industrial trucks safely, including how to deal with underride hazards, to wit, for example, to always look in the motion in the direction of travel of the powered industrial truck, which would have prevented this hazard in the first place.
Mm-hmm.
And in that sense, it is addressed, Chewy argues. The administrative law judge did not agree that training by itself covers it, and nor, for that matter, did the review commission.
Exactly. So the administrative law judge essentially says that, Chewy's methods here were inadequate, and clearly because, this accident occurred, that, Chewy did not prove that the power industrial truck standard preempted the general duty clause, and that OSHA was able to prove all 4 elements of its general duty clause violation. So the ALJ affirms the citation, and then it goes to the 11th Circuit.
One of the other things that Chewy argued was, well, and the 11th Circuit, I think, relies on this, is when you look at the powered industrial truck standard, it does address the possibility of running into or striking parts of a building, such as columns. And in that sense, the powered industrial truck standard is one that covers this kind of underwriting hazard. But I don't think it's on the face of the standard.
Exactly. So I had to take another look at this when I was reviewing this case. The mention of columns and sort of backing into structures is actually in the preamble to the powered industrial truck standard. Not, if you do a search in that standard for the word column, you will not find that in there. And so that's sort of the slight nuance here that we're trying to parse out.
Right. And so this is interesting because when you look at the preamble, it should be treated as an interpretation. It has interpretive value. Maybe it's not on the face of the standard, but what the agency was saying at the time of promulgating the standard is, we believe the standard means this, and that's why we put it in the preamble. And one of the things they said they believe it means is that it has concerns about running into columns or other parts of the building, and that would include underwriting hazards, I would think. So the 11th Circuit isn't entirely off base or without foundation in pointing to that preambulatory language. Okay, so the 11th Circuit's decision is, we agree with Chewy And we think that it's somewhere in the four corners of the standard, perhaps explained better in the preamble, but
Mhm.
it's there.
Mhm.
And that the use of the general duty clause is inappropriate because there is a standard on point.
Right. And so, one of the key questions moving forward, I think, is how do we reconcile these cases? How do we reconcile the 1987, General Dynamics case, which essentially says you can't just operate in the four corners of a standard. You can't. That's not an adequate defense if there was a clear, feasible method of making your workplace safer that existed. You contradict that with what happened in Chewy, where it almost thinks, it almost seems like if you read that in a vacuum, that you could just throw your hands up and say, I complied with the standard, and there was nothing else I needed to do here. I do think, Manesh, that that's a dangerous position for the employer community to take moving forward. I don't think that I would feel strongly advising clients to just say, okay, you complied with the standard. You don't need to look around beyond that to see if there are other feasible things that you can do to make your workplace safer. I would strongly caution against using the holding here of Chewy to sort of justify that sort of head in the sand approach.
Yeah, I think that's right. And I think the way to reconcile these two cases is simply to recognize that every case is fact specific. And the Freon standard is very different by virtue of being a health standard for exposure to a hazardous substance,
Sure.
and the circumstances in which General Dynamics was applying that hazardous substance being so at variation with the general exposure circumstance that was contemplated by the Freon standard. And here we have a very different set of facts and a very different circumstance. I find myself in the sort of difficult position of disagreeing with both decisions. I think that the Freon standard actually did cover the exposures General Dynamics was engaged in, and they should have measured with respect to inside the confined space, whether or not they'd exceeded the permissible exposure limit. And I think that's what OSHA should have cited to, is exposures inside the tank.
Right.
Where General Dynamics was clearly sending workers into that confined space to perform work after the Freon was poured in. Here, however, I'm not sure that I agree with the Chewy argument or the 11th Circuit's. I think there's a very solid argument for OSHA to make that modifications to shelving shouldn't be covered under the powered industrial truck standard, and merely complying with the powered industrial truck standard doesn't absolve them of the need to look at the kind of modifications they can make to the shelving. Perhaps that's more closely covered under the materials handling standard, or but arguably neither the materials handling standard or the powered industrial truck standard cover it. But that's precisely the point I think OSHA was trying to urge upon the court, is that's why it sort of falls in between the two and ought to be addressed by the general duty clause. In fact, I think this is a stronger case for use of the general duty clause than was exhibited in the General Dynamics case.
Yeah.
So I think that the message here is that every fact pattern is going to be different. And that's to your point, Taylor, that it wouldn't be wise to rely solely on compliance with the standard to absolve you from having to look around, see whether there are additional hazards not covered or not adequately covered by standard, and whether there's more that can be done to improve safety. I think that really here, one of the most compelling features to me, Taylor, was whether or not other employers in warehousing and distribution were taking precautions, or did they have such high shelving as their lowest shelf,
Right.
or had they put modifications onto the forklift? It seems to me that the easiest modification would be to the shelving than to the forklifts, because they're not in the space of manufacturing or designing forklifts or powered industrial trucks, but they are the ones who install the shelving and have some significant level of expertise about that, and their product type that's coming in, and why the first shelf has to be so high. That to me is lost. I mean, Taylor, you and I have walked through warehousing, distribution, fulfillment centers at some of the largest employers in the country.
Yep.
And we don't see the lowest shelf being so high as to create that kind of underwriting hazard.
Right.
So what's my point? I think is that maybe one of the things that Chewy could have done was to take stock of what industry standards look like, what generally used methods would be at similar employers, to engage in their community of fellow employers in similar activities, and to learn from shared sort of knowledge of what practices are working.
Yep. And I think just reading the tea leaves here, one thing, that you could see moving forward as a result of this decision is that OSHA could update the powered industrial truck standard to specifically sort of take the language from the preamble and move it into the standard itself, put in the words columns, or, make sure that they're sort of, covering themselves there so that they're not susceptible to, the outcome of the 11th Circuit, moving forward.
That's right. They could not only do so now, but they could have done that at any time.
Sure.
But the rulemaking process is certainly lengthy.
Yep.
If the 11th Circuit believes that this was somehow covered in the standard, I think that the hidden menace to an opinion like that is that it gives the agency the opportunity to argue that this could be addressed through interpretive guidance. But we don't see it that way. I think that this would require rulemaking if indeed OSHA has taken the position that it's not covered under the powered industrial truck standard. So I think that they would have to go through that lengthy rulemaking process. But I think that there is adequate data out there to support the idea that this is a recognized hazard, and that there are feasible, inexpensive means of abatement merely through adjusting a shelving. So hopefully that kind of rulemaking wouldn't be amongst the most involved and protracted and lengthy rulemaking processes.
Right.
All right. Well, we've talked about some of the things employers should do. Let's talk about more things that we think employers should do in light of the Chewy case.
Sure. So I think the first one is that after each incident, conduct an incident analysis and then take a look at your safety protocols and update them based on that. In this specific case, that this is exactly what Chewy did. Their compliance and health manager sort of came up with this idea, hey, why don't we lower the shelving? It ended up not moving forward with it. But I think that's definitely a lesson learned here, could have prevented this from happening.
Right, Taylor. Well, one additional fact about this case that makes your point especially compelling is that prior to the incident where a forklift operator was engaged in an underwriting accident and died from it, there was a prior underwriting event at that facility that resulted in an injury to that worker.
Right.
And so what you're saying is that the safety and health folk examined that earlier incident that resulted in an injury and concluded that lowering the shelves was the right remedy.
Yes.
And that sort of exercise of analyzing an incident and coming up with maybe whether or not there are available remediations that could prevent recurrence is one of the things that employers could do, that they could take a lesson from the Chewy case and implement going forward.
Yeah.
But I think a lot of employers do.
Yeah.
I think another thing an employer can do in light of the Chewy case is take a look at instances where employees or workers are not following their training and document and discipline those workers. You have to have a record, an involved record of monitoring and supervising employees, and when you discover nonconformity to their training, to document it and to discipline those workers. That may or may not apply here, but I think that is an established recommendation simply in order to use the unpreventable employee misconduct defense if an employer ever has the opportunity to use that defense.
So the next one is consider putting new employees under closer supervision and evaluating their safety performance. So in this particular case, the Chewy case, the operator of the forklift was new to the job. So I think making sure that you're evaluating, their sort of, first few days, their safety performance, and sort of implementing any necessary, precautionary measures that you can take based on that is certainly a good idea.
Yeah, I think that's a great point, Taylor. And the next one I'd say, whether or not, Taylor, the folks in the OSHA 3030 community agree or don't agree that with Chewy's arguments that they did indeed comply with the power industrial truck standard. I think we can all agree that complying with a standard is sometimes merely the starting point for a hazard analysis.
Yeah.
And that once an employer has achieved compliance with a standard, sometimes the day-to-day practices sort of roll back from that point of compliance. But in addition, there may be other hazards that the standard may not address perfectly, and that other employers have found solutions to, or that through imagination and innovation, that employer might find a solution to. And so it's important to comply with the standard and then begin the next step, which is evaluating additional possible hazards through a hazard assessment and trying to find reasonable means of abating or remediating against those hazards.
Right. And then finally, review your workplace designs as your company evolves to see if any new standards are applicable. One of the things that happened in the General Dynamics case was that all of a sudden, they were operating in confined spaces. And so sort of taking a step back and looking at that and evaluating based on, your ever-changing workplace and making sure that you're in compliance with any new standards that you could find yourself under is certainly another good idea.
Yeah, and that's right. And Taylor, and when it comes to the space, the sector for distribution and warehousing, something that you and I do a lot of, new product is always rolling in, or the same product is rolling in with new packaging, changing its size and the lifting and materials handling processes. And so that changes the shelving. The shelving goes up and down to accommodate evolutions in the in and out of a distribution center. And so that's another example of having to review workplace designs as the company evolves. The minute you establish a perfect layout for your facility, somebody's going to drop a new product in an aisleway or against a wall that happens to block an exit or something like that. Things are just constantly in flux, and entropy is the one constant in a workplace. And so constantly reevaluating workplace designs is just a necessary part of the day-to-day of any manufacturing or distribution center. Okay, well, Taylor, I think I got the last word on this episode. This is one of the episodes that we've been doing for over 10 years now. All of them we've posted on our website at khlaw.com/OSHA3030. And since we've been doing this for almost 10 years, I think there's almost 120 episodes. I believe August will be our anniversary. September will begin our new year and our new decade. You can catch more updates from us through LinkedIn. I hope you've all gone onto your LinkedIn account and established connections with both Taylor Johnson and myself and other attorneys here at Keller and Heckman, both in our OSHA practice as well as our several other practices. We'll repost this episode as a podcast as well as as a video on our website, khlaw.com/OSHA3030. And we use OSHA, we use YouTube as the media, the platform. So check us out. If you're going to watch us on the YouTube video or on listen to us or download or subscribe to the podcast, first of all, please subscribe. And second of all, please remember to like or rate the program so that it's more easily found by others in the safety and health profession and by in-house counsel responsible for OSHA compliance. With that said, our next episode, Taylor, we always do this in about 30 minutes and we do it about every 30 days. So the next one will be at 1 p.m. Eastern on July 19th, 2023, always on a Wednesday at 1 p.m. Eastern. So July 19th, stay tuned for an email invitation and register for that program when you get that email invitation. But also, as importantly, you've heard us say this before, when you get that email invitation, please forward it on to 3 others within your organization or at other organizations, in-house counsel and safety and health professionals responsible for complying with OSHA law. In addition, we have sister programs, the REACH 3030, the TSCA 3030. Our next programs for those will be at 10 a.m. June 21 and 1 p.m. June 21 Eastern Time. So if your company is engaged in activities that are regulated by those statutes, please, those regulatory schema, I should say, please check out the REACH 3030 and the TSCA 3030, 2 other great programs we do here at Keller and Heckman. Well, on behalf of everyone at Keller and Heckman, and I'd like to thank all of the folk on our team at the firm who helped put this program together, and as well my colleague Taylor Johnson. And on behalf of all of us, thank you, members of the OSHA 3030 community, for participating. We look forward to seeing you again next month. And until then, stay safe.